Assalamualaikum warahmatullahi wabarakatuh. My name is Nur Ashki binti Anwar and my metric number is 1913750. I am going to talk about laws and investigation conducted against crime in Malaysia. Generally, law is divided into criminal law and civil law, but in this seminar we will be focusing on the criminal law. The definition of criminal law is the body of law that defines criminal offences, regulates apprehension, charging and trial of suspected persons, and fixes penalties and modes of treatment applicable to convicted offenders. So basically, criminal law deals with the punishment of the offender. In Malaysia, the law that is applied against crime is the Penal Code. Penal Code is the law that codifies most criminal offences and procedures in Malaysia. It was enacted in the year of 1956 and effective starting from 1976. The official long title is an act relating to criminal offences. Penal Code determines the punishment where it varies with the circumstances. Examples of punishments that can be sentenced to the criminals are fine, rehabilitation, whipping, imprisonment, and death penalty. This punishment has several purposes, which are deterrence, incapacitation, rehabilitation, retribution, and restitution. So firstly, deterrence. Deterrence prevents future crime by frightening the defendant or the public. So when the public learns of an individual defendant's punishment, the public will be less likely to commit a crime because of fear of the punishment the defendant had experienced. So example of punishment that can instill deterrence are sentence of life in prison or the death penalty. So next, incapacitation. Incapacitation prevents future crime by removing the defendant from society. Examples of incapacitation are incarceration, house arrest, or execution pursuant to the death penalty. So next one is rehabilitation. So rehabilitation prevents future crime by altering a defendant's behavior. Examples of rehabilitation include educational and vocational programs, treatment center placement, and counseling. Other than that, retribution. Retribution prevents future crime by removing the desire for personal avengement in the form of assault and criminal homicide, for example, against the defendant. So when the victims or society discover that the defendant had been adequately punished for a crime, so they achieve a certain satisfaction that our criminal procedure is working effectively, in which this will enhances faith in the law enforcement and our government. So lastly, restitution. Restitution prevents future crime by punishing the defendant financially. So restitution is when the court orders the criminal defendant to pay the victim for any harm and resembles a civil litigation damages award. So restitution can be for physical injuries, loss of property or money, and rarely emotional distress. It can also be a fine that covers some of the costs of the criminal prosecution and punishment. So the next thing that I will be explaining about is investigation procedure of a crime. So the method of investigation for a crime is conducted firstly by the crime scene investigator, then forensic, and lastly by the court to prove and punish the criminals. So firstly, crime scene investigation. So crime scene investigation is a process that aims at recording the scene as it is first encountered and recognizing and collecting all physical evidence potentially relevant to the solution of the case. The initial responsibility of the crime scene investigators are to preserve the integrity of the scene and the evidence. So furthermore, they are also responsible for the early documentation of the crime scene, its evidence, and all activities at the scene. So there are 6 steps in crime scene investigation. So the first step is securing the scene. So the area will be blocked off with tape to prevent contamination or removal of evidence, and only essential staff will be allowed to enter the area of crime scene. And the second step is examine the scene. So in this step, there will be a scene of walkthrough and documentation of the evidence. So the walkthrough purpose is to closely examine the area and identify evidence present. So documentation is by taking photographs of the scene. The third step is evidence tagging and collection. So each evidence will be tagged and collected, and all evidence should be photographed in place as found first and later with evidentiary markers, and if necessary something to assist in determining the size of object such as a ruler, pen, coin, and etc. So all the photographs taken will be kept in a log as a record. And the fourth step in the crime scene investigation is a scene sketch. This for scene sketch, the sketcher will do a rough sketch with a true north indicator and measurement of evidence in relation to a point. So the sketch is a complement to the photograph taken at the crime scene. The fifth step in crime scene investigation is evidence storage and testing. So investigators will document, seal, and label all evidence for transportation to a forensic lab for analysis. So the forensic lab will do several tests on the evidence if needed. The last step in crime scene investigation is final walkthrough and the release of crime scene. So an investigation officer, which is the team leader, will do a final walkthrough to make sure there is no evidence has been missed out. So when everything is satisfactory, the investigation officer will declare and release the crime scene officially. So next is forensic. The role of forensic science services starts at the crime scene with the recognition and recovery of physical evidence. So what is physical evidence? Physical evidence can be anything from massive objects to microscopic items generated as part of a crime and recovered at the scene or at related location. So considering all sources of information available in investigation such as confession, testimonies, video survey, and also video surveillance, so this physical evidence plays a really important role. So physical evidence, when it is recognized and properly handled, it offers the best prospect for providing objective and reliable information about the incident under investigation. This physical evidence proceeds with its analysis and evaluation of the results in a laboratory. So when the evidence is brought to the lab, it will be processed and analyzed. The procedure will involve a wide array of physical, chemical, and biological methodologies. The scientific information derived from forensic analysis of collected evidence is critical in helping to solve crimes. So after that, the result of the findings will be presented to judges, prosecutors, lawyers, and others in need of the factual information. So the last level in the method of investigation is the court. So courts are important because they help protect our constitutional rights to equal protection and fair treatment under the law. They also provide opportunity for the parties to have their cases heard by neutral judges where all cases are decided in a fair and consistent manner. Court decisions are based on what the law says and what the evidence proves. And the court exists to do justice, to guarantee liberty, to enhance social order, to resolve disputes, to maintain the rule of law, and also to provide for equal protection to all regardless of background, and to ensure the due process of law. And there are a few basic rules of people in the court to ensure that everything in the court runs smoothly. So the first person is judge. So judge is the person in charge of the courtroom. He or she will make sure that everyone in the court follows the rules. The judge decides if a law was broken after hearing both sides. So after that is clerk. So clerk is a judge assistant which help manage papers and other activities for the judge. There is also bailiff, which is a person who maintains order, announces the beginning and end of the court session. So next is prosecutor. Prosecutor is the attorney hired by the government to try to prove that a charge against an offender is true. Next is lawyer, where the lawyer is the defense attorney who helps the accused person defend him or herself in the court. And lastly, there are also witnesses in the court. So witnesses is the people who may know something about what happened. So the prosecutor and the lawyer will ask questions to the witnesses. To conclude, in Malaysia, the criminal law is encoded by the penal code, and there are several steps in the method of investigation. Firstly is by crime scene investigator, next is by forensic, And lastly, by the court, where the criminals is punished based on their actions. So that's all from me. Thank you. And we will move on to Aida.